Thank you. And next we go to Mr. Grothman from Wisconsin.
Thank you. We'll go to Ms. Watson. OSHA's proposed rule right now, and we talked about this before, adopts a one-size-fits-all rule for heat, illness, and injury prevention. Identical requirements across indoor, outdoor environments across all sectors, including agriculture, construction, and manufacturing, without differentiation. This broad application fails to consider critical distinctions in worksite conditions. How does OSHA justify imposing identical obligations on such a broad and diverse range of workplaces?
Thank you, sir, for the question. Their justification, obviously, is to protect workers. I know that during the rulemaking process, during the SBREFA panels, those discussions and the advance notice of proposed rulemaking, many people requested industry-specific standards that apply to the unique differences among their industries. So I'm familiar with construction, residential construction, so I'll speak to that. Job sites change daily, sometimes hourly, depending on what's going on. And what works in manufacturing, where you might have a static situation, obviously not all manufacturing, but there are circumstances where you have a static work environment. That doesn't change. That's much easier to manage than a construction site where you've got roofers coming and they're installing the roof and then they're going on to the next job site, and then you've got people coming in and doing the house wrap. And so that constant changing isn't helpful, and I think that concern among stakeholders that I've spoken with is that if you treat everyone exactly the same with limited flexibility, it makes it difficult to get a robust plan that is specific to the industry.
It's the type of thing that causes people to hate government, right?
Maybe, yes.
Maybe, okay.
Sometimes, yes, sir.
Okay. You raised many questions about the walk-around rule. We'll kind of touch on this again. Can you expand on potential liability, employer liability in the event a third-party representative is injured during a walk-around inspection?
Yes, sir, thank you. So OSHA actually addressed that because a number of stakeholders raised those during their comments in this process. And OSHA basically responded in the final rule saying that there were plenty of statutes available at the state and local level, tort liability, those types of things, and so OSHA wasn't going to comment or make a determination on that. So essentially, OSHA's not involved in that piece of it. If someone's injured and they end up suing the employer where the job site was, it's up to the state court systems to sort it.
We'll ask Mr. Barab a question here. As I understand it, in my district, we had just a tragedy in which a young man died in an agriculture accident. And it was a small farm. I guess the guy had maybe 3 or 4 employees. Kind of surprised his mother that OSHA would not apparently do an investigation even if somebody died. Could you elaborate on that?
Yeah, you're talking about Stacy Siebold and her 19-year-old son, Mitch McDaniel, who was killed by an auger in a farm in your district. Yeah, OSHA, the Congress has put a rider on OSHA's appropriations bill since the 1970s, saying that OSHA cannot basically step foot on a farm with 10 or fewer employees. They can't go in for an investigation, even a fatality investigation. They can't even go in and pass out fact sheets. Yeah, it's a terrible injustice, and we're seeing, we see a lot of workers, including young workers like Mitch McDaniel, die on these workplaces that, from hazards that are preventable, and where the employer and all employers could learn from an OSHA investigation, yet OSHA is not allowed to go onto those workplaces.
So in other words, if there were 11 guys on the farm, they could have investigated.
Exactly, but with 10 workers could die on a farm, and OSHA still wouldn't be able to go onto the farm.
Yeah, and you could have, if it was a little bakery with 5 employees, OSHA could get involved.
If somebody got killed in a bakery with 5 employees, OSHA would get involved, yes.
But for some reason, can you think of any philosophical reason why, if somebody dies, we're not even going to talk about somebody becoming a paraplegic for the rest of their life, somebody dies under the current law, we apparently don't express it.
I think we're dealing with the power of the agriculture industry and the so-called sanctity of the small farm. I don't know. This is kind of a myth, again, that was created, and this, again, that's been on the books since the 1970s. It makes no sense, and workers are dying because of it, so.
Well, thank you for pointing that out.